my client is fully willing to admit that he failed to do the retests, failed to show up for the ETG, though he would like to provide some context to the court to that. Obviously, he's also would explain that he is in violation of the using a mouthwash. However, he is maintaining that no intentional alcohol substance or consumption took place.
Okay, look. Okay, I get all that.
Yep.
I'm not here to play a game. He's at 056. He's not getting there with Lister.
Your Honor, I honestly have never done one of these hearings on SoberLink. In researching it, I did find some studies that to me indicate that could be possible.
And Your Honor, technically, it could be possible if you were chugging the Listerine and then after chugging it, you blew into the SoberLink. Our agent Mormon, he can testify to the numerous cases that he's worked, and that is the only time that he would have seen that. I also, if needed, I do have the SoberLink expert. He's currently in a training today, but I do have the person who does all the tethers, and you're familiar. I've had him testify at PCC, and it's the same thing as when we had the gasoline hearing. It's the same thing as the ethanol. It doesn't trigger it.
I understand that, Your Honor. I've never cross-examined this expert before. I've never, I wasn't at these prior hearings. All I can represent to the court is, obviously, I don't have an expert to present, but based on 2 scientific studies, and they lay out the methods that a reading of 0.056 is not impossible. I would say it would be approximately 10 minutes or so after use based on these studies. But I'm happy to provide them to the court to see.
Okay. Then Mr. Ward. Wouldn't we all know that had he taken the retest? So there's part of the problem. Part of the problem is that I've seen this pattern before, time and time and time again, where, let's see, just so that we're clear on everything. 10 o'clock, get the test result. Retest is called for 10:12. Well, 9:57 was the test where we get the results. 10:12, no retest. And he knows it's part of the program. He's got a retest and the machine's calling for a retest. Then we go half an hour later. Schedule a retest, doesn't happen. So that's 2 retests. Approximately half an hour after that at 11:12, retest, didn't retest. 11:42, retest, didn't retest. Now we get into the morning, schedule a retest, no retest. 11:40 or 12:42 a.m. schedule a retest, didn't do that. Finally, at 7:13 in the morning, he submits a compliant test.
And Your Honor, I did, and there also is the statement regarding I'll get there when they requested an ETG test the following day. And my client fully admits he realizes what it looks like to the court. He realizes this court sees this. I explained to him, it's, if.
Well, let's just have the hearing. I mean, if he's not budging, let's just have the hearing.
That's fine.
Because then I'll do what I got to do.
Yes, Your Honor, and we certainly can have the hearing. I assume I know what Ms. Kirby is asking for. My client does take this seriously. He He's a veteran. He has engaged in substance abuse treatment in the past through the VA. Is definitely willing to continue to do treatment. And I'm happy to help assist him in locating treatment. He understands the extreme loss of accountability to the court in what happened. He would be requesting to switch to the Scram monitor if the court was willing. So obviously we're willing to admit the lack of accountability, the lack of retests.
No.
Yeah.
You can admit what you want, and I don't think you get to pick and choose.
I understand.
So if what we want to do, if we want to have the hearing, we'll have the hearing. I mean, I think it gets worse from my standpoint, and I would presume from yours. If I go through this hearing and I make a determination based upon what is being submitted to the court, that not only in terms of what happened, but that then somebody's lying to me. Because that person, I would believe out of the get-go, is not amenable to treatment. And I'm presuming, Mr. Ward, you've explained that to your client.
I have, Your Honor.
If you want another opportunity to explain it, now that we're all looking at each other face to face, I will give you that opportunity. Otherwise, we might as well just start taking the testimony.
If Your Honor would grant brief recess to discuss further.
Go ahead.